Hello and welcome to Unpacking the Case, a podcast by Davitt Jones Bold, the real estate law specialists. I am your host, Lizzie Collin, and today I am joined by our Head of Legal Training, Richard Snape. Hello, Richard.
Hello, Lizzie.
Thank you very much for joining me. We're just recording today off the back of your recent webinar on the 26th of May. This was a local authority webinar that you did on disposal of development land, in particular featuring restrictive covenants.
Mm-hmm.
So I think today we're just going to delve into 5 or 6 of the cases that you kind of glossed over in that session. So we're going to start with looking at charitable trusts and the case of 2002 Attorney General and Bath and North East Somerset Council. So can you just explain, first of all, the background of the recreation ground in Bath?
Yeah, I mean, it's an incredibly complicated case, and I don't want to go into huge detail in charitable law because most people who listen in will not deal with it in great detail. It's a question of spotting. I'll tell you the background facts. I mean, as I mentioned in the webinar, I know the area well because I used to live there. It used to be part of the Bath Rugby Estate, which was if you want the history of it, if you want a bit of history, then it all developed when Bath developed southwards. When Pulteney Bridge was built in 1774, in the area to the south, large part of South Bath is actually within the Bath Rugby Estate, which is where the recreation ground is. But back in 1922, and we'll come back to that when we get onto restrictive covenants, the land was sold off in this particular part, about 15 acres, so a tidy amount of land was sold off with covenants that this was to not to the council quite yet, but with covenants not to or to use as open space and to use as recreation ground and basically not to build on the land. Back in 1956, they did sort of allowed some building work, 2 sides to a football ground, which also had rugby there as well, primarily rugby ground. I should also mention there were also covenants that you shouldn't favour one type of sporting activity over another. But in 1956, the then owners of the land found that they just couldn't afford to maintain the rec. And so that's when they transferred to Bath and North East Somerset's predecessors, Bath City Council. And it was transferred on trust, for the benefits, to be as open land and for the purpose of recreation for the public at large, but specifically the locals of the Bath area. Council, back in 1995, there's already been leases there, but renewed a lease to Bath Rugby Club, a long lease for 75 years. And in the interim, they'd also, back in the 70s, I think, they'd allowed the building. They built a leisure centre, like a typical 70s leisure centre, and a car parking area. They then, in the year 2000, the rugby club sort of wanted to expand their stadium because it's quite a small stadium. And that's when the problems started to arise because the residents nearby started to do anything they could to stop this development. And the first point was the council wanted a declaration as to whether it was held on charitable trust or not, because if it's held on charitable trust for a specific purpose, a designated purpose, you're supposed to get the charity commissioner's consent before you lease out the land, and you shouldn't be building on the land if it's in breach of that purpose and the likes. So that was some of the background to it.
So what did the court decide then? The
court decided that it was held on charitable trust. I've got great sympathy with the council for not knowing that initially, because I would advise not to read the law report unless you can't sleep at night, because it's page after page, and frankly, it could go one way or the other. They were trying to argue with the council that it's just held for statutory purposes, or there's something called the Physical Training and Recreation Act in 1937. It's there for the purpose of providing physical training for the people. There have been previous cases involving Richmond-on-Thames and also Liverpool City Council involving recreation grounds where they'd held that it wasn't a charitable trust. On the Liverpool one, as I recollect, it was on the rather flimsy ground that when they acquired this site in the early 1990s, they paid stamp duty, which you don't have to if it's for charitable purposes. But for whatever reason, the High Court decided that it was a charity. It has to be for the public benefit and not a specific benefit, a specific section of the public. But they decided, because it said it was for the benefit of the public at large, that was a public benefit and it's a charitable trust. And Bath and North East Somerset and their predecessor have been in breach of that. That's the background.
So what happened next? What was the consequence of that decision? I think if you could bring in the Baddeley and Sparrow case of 2015 as well, and how that relates.
Well, what then happened is the Charity Commission got involved in it. They can create a scheme to deal with this. The council were in breach of their sort of charitable trust duties and duties in relation to this. But the scheme basically allowed things to go ahead with a few modifications, and the residents went also to set up a new trust of the recreation ground, which would have Bath and North East Somerset members as members of the trust, but not solely, and Bath and North East Somerset wouldn't be directly involved in this. The residents objected to that and went to the first tier tribunal. The first tier tribunal wanted the lease of the rec and the rugby club changed, but didn't really deal with that in too much detail. They didn't think it was feasible to knock down the leisure centre and knock down the car park, but it's got limited life expectancy. Tempted to say it sticks out like a sore thumb, but the idea would have been that just you don't renew it at a later stage. That was then appealed to the upper tribunal, still goes on to the upper tribunal in 2015. And the upper tribunal basically said, again, it's a sort of, quite frankly, a policy decision. The scheme that the Charity Commission should have wanted to impose was fine. They said that there probably wasn't a breach of the trust. I really don't understand the argument here, because the wording initially is that the land had to be used as open space and for the purpose of recreation for the public. And they said that the only purpose was the purpose of recreation, and open space wasn't a purpose. And so there was no breach by allowing building anyway. That was the next stage.
Okay, are there any further developments?
Yeah, the latest is from late last year. I'll mention it when we get onto restrictive covenants shortly. But there was then a case called Bath Rugby Club and Greenwood, where the residents tried another tack, and that's the restrictive covenants and the conveyance from back in 1922, again, to use an open space and also not to build anything that might cause a nuisance. And suffice to say, we'll come across nuisance a bit later on, but the court last year decided that the restrictive covenants would be breached by allowing the sort of development of Bath Rugby Club. I understand that's going to the Court of Appeal. So it's from the year 2000, when the problem started, it's going to be at least 2022 before we know the final decision. It is like jaundice and jaundice in Bleak House. Literary reference there, Lizzie.
Yeah, thanks for that. Okay, so shall we move on now to a case in relation to discharge of restrictive covenants? That is Shaviram Normandy and Basingstoke and Deane Borough Council from 2019.
Yeah, I got a couple of questions about this, and so I ended up talking about it more than perhaps I intended to. But I think it's a highly significant case, not just its specifics, but what's happening at the moment. It was about Section 84 of the Law of Property Act, whereby you can go off to the tribunal system, the Lands Chamber, and discharge restrictive covenants on various grounds, not least of which they prevent reasonable use of the land and don't secure practical benefits. And this particular case it's a good reminder, actually, that it applies to some, not just freehold, but leasehold covenants, specifically when you've got a lease of more than 40 years with more than 25 years unexpired, which was the case here. As the name suggests, it all took place in the centre of Basingstoke. Another place I know, and some of the people listening will know, because I've done quite a lot of courses there, local government courses. And it was the former IBM offices in the middle of Basingstoke. They were granted a lease in 1984, a 150-year lease, and they got user covenants to use for business purposes and not for residential. for offices, basically. It was empty for some time, but in 2015, Shaviram Normandy took an assignment at the lease, and wanted to convert it into residential units and sublet on the short-hold tenancies. They, in England, not Wales, but in England currently, more of this shortly, with a lot of provisos like prior approval from the council, you can convert offices into residential units without planning permission. And that's what they wanted to do, but that doesn't ride roughshod over any restrictive covenants. And so they needed to get the covenants discharged, and the council refused. So there were no planning issues, but the council refused to discharge the covenants. I mean, eventually, the council was basically arguing that this is the thin end of the wedge. If we allow these offices to be converted into residential units, all the other offices will get converted into residential. The court decided, or the tribunal decided, and I can vouch for this, that there's more than enough office space in Basingstoke. And so that wasn't necessarily a good argument, this thin end of the wedge. And they also held, as a matter of fact, and I'd leave this to the valuers, that you might be getting less rental from tenants if you sublet on short-hold tenancies, but the capital value will increase. So it was held that the covenant should be discharged.
Thank you, Richard. Can you foresee any problems in the future?
Well, there's a couple of things, and again, this is questions that were raised during the webinar. Firstly, soon after Shaviram Normandy, which was from the summer of 2019, we had a Supreme Court case that I was discussing, secret nominees in Hertford, which basically was about consents to getting a landlord to give consent not to be unreasonably withheld before you made a planning application. And secret nominees, the Supreme Court, by a majority, said that the landlord can take into account their own interests unless the tenant's interests far outweigh the landlord's. And they also said that you should look at the circumstances at the beginning, if you like, when the covenants were created, rather than at the end. And they also said that they would apply equally to alienation, user, alteration covenants. So whether that's a bit of a game changer is another matter. I doubt it, but the bigger problem, I think, or the bigger issue, is in England, again, not Wales. The changes that are going ahead with user covenants and use classes in terms of planning. Because last year we had, well, the transitional provisions are still going on, but we had a A1, which is retail, A2 use, which is professional services and financial services, and A3, restaurants and cafes, and Class B, business premises, all subsumed in one big Class E. And as of August the 1st in England, we're going to have a new Class MA, which stands for Mercantile Abode, whereby that new Class E can be converted into C3 dwellings, subject to prior approval from the council, but no planning permission. And landlords, if they want to prevent a certain type of use, who knows what's around the corner in the use classes, but if you don't want your properties to be used for residential purposes, then or you want to keep them as retail, or you want to keep them as financial services, or likewise in relation to freeholds, restrictive covenants, I think you've got to think carefully about the use classes being changed and introduce restrictive covenants against what you can and cannot use the premises for. But bear in mind, in the longer leases and also in the freeholds, those restrictive covenants are subject to questioning under Section 84 of the Law of Property Act. And I think solicitors, when they're drafting leases, have to think very, very carefully about the restrictive covenants, and what you allow and what you don't allow, or what you don't allow subject to consent. And don't just refer to the use class, don't just say Class A1, because you might just find that's redundant in the future.
Okay, thank you. That's really helpful. There's another kind of related area we wanted to move on to, and the nuisance and annoyance covenants. And you mentioned Bath Rugby and Greenwood already. I don't know if there's more you want to say on that one.
Yeah, I'll come back if I can to that one, Lizzie, but I'll start off. I mean, basically, you see all the time nuisance and annoyance covenants, sort of residential developments for years and years. The Bath and Greenwood, if you remember, it was a covenant created in 1922. And I know certainly in the private sector, residential conveyances, 90% of the developments since the 60s have got these covenants. Right, Davies have these covenants in them all over the place. And a lot of people just let them pass by. What on earth does that mean? And it appears it means much more than you might imagine. I did also mention the case called Davies and Dennis. And I'll give you the facts of that, if that's okay.
Yes, please do.
It took place in Berkshire. It was a place called Heron Island, which is in Caversham on the River Thames. Caversham occasionally is in the River Thames, actually. It's an island, but it's got vehicle access and the likes, and it's sort of like a promontory sticking into the River Thames near Reading, on the edge of Reading. And they, back in the 80s, I think the buildings were completed in 1987. There were 47 houses built on this Heron Island. And there's got open space and the likes as well. And all these there were 3-story houses, I suspect quite expensive properties with views of the river. And they set up a management company, as you would do on these kind of things. It was managed by Peveril, as they were, First Port nowadays. And there are things like consent to plans, alterations, covenants that you had to, if you're going to do any work on the premises, you got to get the management company's consent. But there's also covenants not to commit a nuisance or annoyance. Again, this was from 2009, and people just let these things pass them by. Somebody got planning permission to build a 3-story extension, can basically extend their building up to the full 3 stories. And neighbours objected to the fact because it would partially block their views of the river. And so they went off to court, and eventually in the Court of Appeal accepted that. Seems to have been a question mark over whether consent of the managing agents had been obtained or not, but they said that would be irrelevant. And they got an injunction because there was a nuisance and annoyance. They said the building work alone could constitute a nuisance, but blocking your views of the river was an annoyance, and it was actionable. And that was a real game changer, and people didn't really pick up on it at the time. But anyway, that's Davies and Dennis.
So how does that affect the long-standing rule that there's no easement to a view?
Well, there still isn't an easement to a view. I mean, it's one of the 2 oldest cases I ever mentioned, and that's the case in William Aldred's case from 1610. And it's still good law to this day, because easements have got to be sufficiently definite, and a view can't be defined, if you like. You can have a right to light through windows, and they're very, very common, but not a general view. The answer, I suppose, is that you can't have an easement to a view, but if you've got a nuisance or annoyance covenant, the restrictive covenant does the same thing. And again, that's a game changer, because 90% of estate developments in this last 40-odd years have that thing. And as I mentioned previously, council had right to buys of a view, the rights to a view. And you might be entitled to an injunction or potential damages.
So are there any subsequent issues or cases?
Yeah, there's been several actually, and several discussions that have, to my knowledge, not actually reached the stage of going to court. There was a case mentioned in the notes, I didn't actually mention it myself, called Coventry School Foundation in Whitehouse. It was briefly mentioned as an aside because you've got to show that you've got land that's benefited before you can enforce a restrictive covenant. The High Court in that case said that you could look at extrinsic evidence, not just at the conveyance, the likes, to decide what was the benefited land. And that was confirmed, although the Court of Appeal decided there wasn't any evidence of benefited land. In 2013, the Court of Appeal also dealt with the nuisance and annoyance side of things. The Coventry School Foundation had a couple of junior schools that they wanted to close down, and bought a site where they were going to build a bigger junior school, subsuming the 2 of them. And there were restrictive covenants on the land, 1930s covenants against a nuisance or annoyance again. And some of the local residents didn't want this school and argued that there'd be a nuisance or annoyance to the highway because during the school run and the likes, you'll have people parking all over the place, the kind of thing, and lots of traffic and the likes. And all these properties, I say it was held eventually that they couldn't show what the benefited land was. This was a big 1930s estate. But the Court of Appeal, unlike the High Court, said that that wouldn't constitute a nuisance or annoyance. It wasn't actionable to be using the highway, the public highway, for the purpose of school run. They basically said it's, I've seen it in landlord and tenant cases as well, but if you're in a town or a big city or whatever, you've got to give and take and just accept those things. So that wouldn't be a nuisance or annoyance. The case, the Bath Rugby and Greenwood case, which I sort of mentioned in the context of the wreck in Bath, the case from late last year, they were arguing that if you develop this site, they were originally intending to have a big leisure centre and hotels and the likes in North Parade and Bath's got more than enough of that kind of stuff already. But that would constitute a nuisance or annoyance because the covenant said that you shouldn't build to the extent, this 1922 covenant, so you shouldn't build to the extent that there's a nuisance or annoyance. So that was one of the reasons. We'll have to see what the Court of Appeal said, but that was one of the reasons that case, again, the restrictive covenant side, the court decided in favour of the residents. The other thing, perhaps, I should mention, I mentioned a case called Braintree, ex-party halls from the year 2000 about council house right to buy and how you can't charge for discharging covenants, development covenants like single private dwelling, consent to plans alterations. But in Halls, they specifically said that it wouldn't apply. You can enforce estate management, if you like, covenants like nuisance or annoyance, not to commit a nuisance or annoyance because that's about managing the estate and they are valid. And even if you can't stop the building work, if you like, under a single private dwelling covenant, if it's a formal right to buy, I think the consensus is, and there have been not cases, but certainly lots of examples of it, you could sue in damages for a nuisance or annoyance. Individuals could sue in damages, potentially the local authority, based on lost value of the land and the likes.
So the Bath Rugby and Greenwood covenant you mentioned was from 1922. Are there any issues surrounding these older covenants? Yeah,
they can be very difficult to find out about. It's and a lot of people just ignore the older covenants. The Law of Property Act of 1925 came into force in January the 1st, 1926. And it's the provision that's section 78 is the provision. It says that the benefit of restrictive covenants is deemed to pass to successors. You don't have to state it. It's sort of statutorily implied. And if you don't like that, there are cases which sort of fudge it a bit. But you should make clear that the covenants are personal, but it only applies to covenants from 1926 onwards. It's not applicable to pre-1926 covenants. And you often find that they're not showing up on the register, or they'll be on registers on first registration. But it'll have something to the extent, no details provided. And they did accept in Bath Rugby that you could again introduce lots of extrinsic evidence as to, because they referred to the Bathwick estate, which is a huge area, as I mentioned it, referred to, the people, the neighbouring premises had the benefit and the adjoining owners had the benefit. But they accepted that with a bit of research, you could find out who were the beneficiaries of the covenant. And so they had a cause of action. And you can't assume that older covenants are not resurrected. The suggestion amongst some, if it's a development site, and you might just check in libraries and public records and this kind of stuff. If it's something a little less than that, it's probably an insurance policy, just in case. Yeah. So there are a lot of issues. It'll be interesting to see if it does, if and when it goes to the Court of Appeal, what they have to say about it, because it could be a highly significant case.
Okay, thank you. That was really interesting. I think we've covered quite a lot there. You've been listening to Unpacking the Case, a podcast by Davitt Jones Bold, the real estate law specialists. We'll see you again in our next episode.